I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are stomping into number 242 on our compilation list. Today we will be in two judges' courtrooms. Because of the length of the proceedings, we will only cover two on today. And before I give you their names, don't forget to like, comment, share, and subscribe. Also, commentary will be left in if there were any commentary in these proceedings previously. Also, even though we're only covering two chapters, still will be added for your convenience. Now, the first judge courtroom we will be in is Judge Rocky Coss out of the state of Ohio. And last, we will be in the courtroom of Judge Jessica Hammon out of the state of Michigan. I hope you guys are enjoying these compilations. If you are, please leave a like, please comment, share. Once again, subscribe. Help us out here on the channel to keep these compilations going. I appreciate you guys. And now let's jump into 242.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right. Just a minute. Be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Coss. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
So, Mr. Taylor, is it, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process here, this pretrial hearing, I got motions I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake. And you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that, there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions that based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yes.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I want to ask to have my attorney removed. I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV. This is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws. I got
motion. What kind of motions are you talking about, Mr. Taylor?
Well, one is a motion to suppress. I got one here. It's
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Well, if you know so much about the law, you should be able to answer that question. I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file the motion.
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
That's on my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I like to remove my attorney and get another one.
Okay. Well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds. mean, I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay? I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer. Now, any other things you want to bring up, Mr. Taylor?
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things out of my discovery. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of the what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery because you've got everything that he's got. And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. With the court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position, and for me to allow you to represent yourself will be guaranteeing you a conviction. You'll be getting convicted of everything. You don't know what you're talking about. Have you ever picked? Do you know what the word voir dire means? Okay. Yeah. Do you know what the separation of witnesses is?
That's one of my motions. Motion to seven.
Well, we don't get no separation of witnesses. I ask you.
Yes. Yes.
What is okay? So what is it? Huh?
Motion to ask him to file.
Okay. Well, that is filed at the time of the trial. When we start the trial. That's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file to get. You cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other people.
No, I'm not.
Because he thinks there's a set number. Sir, he thinks
Be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, what
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. But your attorney has those, and he's shown them to you, to understand it, right?
Yes, he showed me the digital stuff. But he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
cross-examination would be based upon their report.
Also, the submission report to the PCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it.
Doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be.
CI's. Yeah. He has the CI's criminal history. He just doesn't know how to read the discovery. We provide the CI's.
Okay. So,
He doesn't understand what he's reading.
Right? Correct? This right here is a signed paper that's the end of my particulars. That right there, my daughter needed a commission slip to go to school. I can put this on it. That there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
all right, well, I don't really, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
Legal process.
All right, wait a minute.
I can answer this too. we don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
the bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some more, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information is out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped cancel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that either one doesn't exist or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused everything. I got this form smoking crack in the video, but he dismisses it, justifies it. It says I'm smoking a pipe, and nowhere in the video I'm smoking a pipe, but he dismisses it and justifies it.
Well, it'll be in the trial. I mean, if whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney says you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And most likely what will happen is you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial you representing yourself and then coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. Again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. And unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made. I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pretrial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. And if there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
I'm saying I'm getting my just every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything, other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, you're on.
All right. Thank you.
Well, guys, we've come to the end of this proceeding, and for sure, Judge Rocky definitely is a no-nonsense judge, and he's also pretty comical with some of the comments that he made to Mr. Taylor. But as we can see, Mr. Taylor didn't go full soft sit, definitely asked for the bill of particulars, which we hear a lot of sovereign citizens ask for. But this was the first time I really heard an attorney address what the bill of particulars are. And, I won't rehash it. You guys heard it for yourself. But it was interesting to hear that because I had never heard anybody really give that type of clarity on what it is in any of the court proceedings that I've covered. But we see Mr. Taylor, he's talking about trying to suppress the undercover buys that he was involved in. Sounds like he has a drug problem, and hopefully it's something that he gets under control, and not only under control, but obviously something that he stops, because we know drug use, long term, short term, whatever term, it's not a good thing. But Judge Rocky definitely wasn't trying to hear anything that he had to say. And like I said, he had a few comical remarks to him. He told him, listen, he shouldn't be trying to do anything that he's seen online or that he's seen on TV. And I thought it was pretty comical too, when Mr. Taylor was explaining to him how he was receiving his evidence. One day he'll get it here, and a few days there, a week later there. And Judge Rocky was like, listen, well, that'll give you something to do, being that he's locked up. So I thought it was, kind of comical the way Judge Rocky handled it, but also he was very firm, stern with, the way he handled everything. We see that this case has been continued, and I will follow up and get that next part for you guys, his next proceeding, so that we can see how this thing plays out. But with that being said, guys, as always, I appreciate you guys joining me for these proceedings. It is a pleasure to see your comments in the comment section, all the super thanks, all of the different things that you guys do to help out the channel. Just know that it is much appreciated. Thank you, thank you, thank you. If you're new to the channel, subscribe, like, and share. If you are not new, like and share. It is much appreciated as well. Excuse me. And with that being said, guys, once again, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I'll catch you guys on the next proceeding. God bless.
All right, and so this is case number 25T01947FY, people of the state of Michigan versus Robert Wayne Sigsbee. And counsel, you can place your appearance on the record.
Good afternoon, Your Honor. Mitchell Young for the people.
And Mr. Sigsbee, if you could state your name, please.
Robert Wayne Sigsbee.
All right,
Yeah.
and
Executor, beneficiary, kind of formal.
all right, and we are here today on a probable cause conference. We had a hearing on July 31st. At that point, Mr. Sigsbee had stated that he was wanted to represent himself. We had a long conversation about that at that time. And I did determine that Mr. Sigsbee would be permitted to represent himself and that Attorney Hilliker would no longer be appointed on the case to represent Mr. Sigsbee. And so then at that time, Mr. Sigsbee, you stated that there was some more discovery that you were looking for, body cams and some other things. And so we adjourned to today's date. And then we find ourselves here today. So on that note, Mr. Sigsbee, do you have all the discovery that you were looking for?
I do not. I wanted to confer with the prosecutor and I had more paperwork to turn in and I worked tirelessly to get the paperwork in. I got it in. There was no more overnight mailing. So I got it in on Tuesday. I don't know if the prosecutor, David Layton, had received the add-on to the paperwork. I see this prosecutor here has zero paperwork in front of him. So he didn't even get the first paperwork or all of it was sent in. I don't know, Mr. Prosecutor, did you receive any paperwork?
I think they do everything they have a system called Carpel where they do everything digitally. So if he does have a digital file with your paperwork in it, probably
It looked like this.
I believe, Attorney Young.
Your Honor, I'm unaware of anything that was given to our office. My understanding is that Attorney Hilliker provided all the discovery that we gave to him to Mr. Sigsbee, and from there he has everything that we have at this time. We did provide Attorney Hilliker the body cam of Officer Isaiah Voorhees, and that is all I have in regards to body worn camera at this time.
Go ahead.
Yeah, I want to be respectful.
Thank you.
So what I said in the last PCC, seeing as how we don't have a Fifth Amendment indictment here, we're going through this process. I feel it's very constitutional not to have an indictment. There was supposed to be body cameras from the other officers, roughly between 9 and 12. I could hardly count how many police were there because of what has happened on the side of the road. It would exonerate me if I had different views of the behavior and the actions of the arresting officer in this civil infraction.
All right, so
The fruit of the poisonous tree has been definitely happened.
Your Honor, if I may, I'm obviously not an expert on the facts of this case as I'm just covering today, but my understanding is that the body cam of the arresting officer was provided, being Isaiah Voorhees.
If I may.
okay, well, hold on, let me ask a question. So on that one body camera of the arresting officer. Do you have that, Mr. Sixby?
I do.
Okay,
And
so
what-
you have the one. It's just the other ones that you
Right.
want. Okay.
Exactly, because what the deputy did is he concealed he put his body camera on this side of me and blocked it while he reached into my bag and into my pockets. I was cuffed. And he reached in the pocket. I looked down and seen him pull out my Native American herb. And then he stuffed it back in my pocket, but I thought he took it with everything else and threw it into the vehicle. So that right there would exonerate me that I did not bring nothing into the jails. He did.
No malice.
Okay. Nope. Nope. Mr. Renfro, you don't have any standing to talk, so I'm going to let you stand there. But that is all I'm going to let you do. You can't say any words today.
I am appearing next, friend.
You are not, because that is not permitted by the Michigan court rules. You can stand there, like I said, I'll let you do, but if you keep talking, I'm gonna make you sit down, and then if you don't follow those rules, I'm gonna have those nice gentlemen back there escort you out of the room,
Thank you.
okay? So, remember, my rules, my court, it's just how it works. Okay.
Objection. I'd like to have an objection.
Sure.
The definition of court here is the person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue. This is my retinue. Black Law's Dictionary is cognizable by the Congress.
All right, this is the 67th District Court. I'm the judge of the 67th District Court, and that's all I'm gonna say about that, okay? So whatever that objection is, it's overruled. Okay, let's get back to the issue at hand, though. The issue at hand is that Mr. Sigsby would like some additional body camera footage. Attorney Young, I know that you weren't here last time on this case, right? It was a different, I think it was Attorney Trummer, I think.
I believe so, Your Honor.
All right.
It's either him or Attorney Bokrakus.
So here is what I'm going to say today, what I'm going to order today is I do think that it is relevant, and I think that it is pertinent if there are other body cameras available of officers that were there on scene, then I do believe those need to be turned over to Mr. Sigsby because I do find them to be relevant. And I think that it's not unreasonable to want those things prior to the preliminary examination. So I am going to order that those be turned over. I'm also going to state, though, that the discovery is what the discovery is. And so sometimes there are situations where people think there is additional discovery that does not exist. So if there is 5 body cameras, then there's 5 body cameras. And if that's what the prosecutor's office says that that's all they have, then that's all they have. So we're gonna order that everything the prosecutor's office has needs to be turned over. If there are additional body camera, they need to get that and they need to turn that over. But we're not going to continue to have a conversation over and over again about discovery that needs to be, or that discovery that Mr. Sigsby you think might exist that doesn't exist. So when we come back next time, I'm going to expect the prosecutor's office to turn over everything they have, and then we will move on to the preliminary examination phase, because we got to start moving this case along at some point.
So Michigan.
Hold on one second. Attorney Young, how long do you think it will take your office to get that additional information for Mr. Sigsby?
Seeing that this is the Genesee County Sheriff's Office, I should be able to get it relatively quickly. However, the videos would need to be reviewed prior to release. I'm thinking 2 weeks would be more than enough time. I could probably do it if I'm lucky by the end of this week, really, to get them. So I'll leave it to the court and I'll get it done. But I'd say either a week or 2.
Right.
Mr.
Mr. Sigsby?
So the problem I have is a couple of them is one, Michigan State Constitution says I get to confer with the prosecuting office. I'd like to do that.
Sure.
And then another thing is on a scene such as that one, you'd think every one of these cops would have, police officers would have their body cameras running. So if he wants to look at them ahead of time and said there is none, no evidence, I'd say that was conspiracy against my rights at that time under United States Code 18 U.S.C. 41.
But we're not even there yet.
I get it.
So
I get it.
so-
But okay, the video I got there's a chunk in there where he says if this man would have been by himself, I would have, and it went blank. You can see the lips moving, but you can't hear nothing. So the editing process is taking away exculpatory evidence.
Those are things, so
If he
Those
threatened
are
me
the
with
things-
death,
those are the things, whatever happened, those are the things that get brought up in front of the jury. You can bring them up in front of your preliminary examination as well, but they get brought up in front of the jury to show weight of evidence. If you're claiming there's evidence that's missing and things like that, those things absolutely can be brought up. It's just that we're not going to prevent having a preliminary examination by saying that you think that there's evidence out there that they're saying that they don't have. Do you see what I'm saying? So once they say, this is all we have, these are all the cameras, then we are going to have the preliminary examination. That's all I'm saying. So we're going to give you time to do that though, and give you time to talk to the prosecutor's office
Sure.
once you have that information. All right. So having said that, let's pick a date for the next court date. I think Attorney Young, you're right. I think to get the information to Mr. Sigsby and then give Mr. Sigsby and the prosecutor's office, everybody time to review everything and then give the parties time to talk if they want to. I think that setting this for one more probable cause conference, I will find good cause to do so. I do think that's a good idea. And I'm looking at September 4th. Does that sound like a good day to everyone?
well, I'd like to get 21 days so I could send the prosecutor a proper notice of non-response.
That is appropriate.
Oh, you got good math.
Do you want, I can give you a little bit, we can put it on the 11th.
Well,
if you want. Give you
I
a
would
little
like it on the 11th. The reason being because I'm going to send a bill of particulars. If this county does not recognize Fifth Amendment indictment, then they're going to have the bill of particulars because without that, the substantive due process has been violated on its face. There is no indictment on this felony charges, and it is the fruit of the poisonous tree. So I'm concerned that the Constitution of the United States is not being followed on its face by all
Yeah.
parties.
Here's
It's a
what-
point of order.
So
Point of order is a real, what, I got to get it out of the law book again?
I've looked at Mr. Sixby, I've looked at everything that you filed. In fact, not only have I looked at it, I've highlighted it, and I've even made my own notes.
I see you.
So please know that I do read everything that's put in front of me and
That's
I take
blessed.
it seriously.
Thank you.
But a lot of what you filed is not relevant nor pertinent nor accurate law in any way. And a lot of it too, it's not filed properly in the sense of this. You have to file it as a motion. So if you do have a motion, we'll hear your motion at the next court hearing, okay? But it has to be filed as a motion. For example, some of these things like judicial notice of adjudicative facts, notice and demand to cease and desist inland piracy.
I'm not an attorney.
Hold on. I'll let you say it when I'm done. It's nonsense. It's nonsense and I'm not gonna address it. Notice of document filing, things, affidavit of truth. One thing I did want to point out to you, you filed your birth certificate in this file. This is a public file. So people could go and get a copy of your birth certificate because it's right here in this paperwork. I would have not done that. I'm not giving you legal advice in any way, but that just doesn't seem like that's a good idea. I just wanted to point that out to you because when I saw that, I thought, that's not. I also have this appearance of next friend and these things they're just not.
They're
They're
Supreme
not-
Court.
Hold on, stop. I'm gonna let you say those things in just a second. They're not permitted under the Michigan court rules. There's no statute that permits things like this to be filed, and frankly, there's not going to be. I'm not going to spend a lot of time addressing them because they're not relevant to these hearings in any way. I just wanted to let you know that.
I object on the record to be reserved on the record to correct the record. The Supremacy Clause of the United States does bind you to all of this. Article 6, Clause 2, you're in breach of that clause for saying Michigan does not recognize these. You guys are foreign citizens. Title 28, 22, United States Code, Foreign Relationships and Intercourse. Chapter 11 identifies all public officials as foreign agents. Federal Rules of Civil Procedures 4J states that all courts, jurisdictions, and immunities fall under foreign state. 22 CFR 92.12-13, foreign relationships state an oath is required to take office. The 11th Amendment, foreign citizens cannot invoke the judicial powers of the state. 28 USC 3002-15-8 defines the United States means a federal corporation. Michigan is a franchise, and so is this subdivision is a franchise of federal corporations. Corporations have no parity with the tangible. And Howard versus Dolan's administration. Governmental actors are foreclosed from creating and attaining parity with the tangible. These are res judicata, Supreme Court laws of the land. Now, I'd say that was treason on its face. The judge has just committed.
Yeah.
Well,
I've been accused.
I'm a living man.
Stop. I'm talking now. I've been accused of committing treason before, not committing treason. Everything you just said is nonsense, and it is not applicable in this court. We're going to leave it at that. We have a court date now set for September 11th, 2025 at 11 o'clock a.m. That will be a probable cause conference. We will be, hold on, let me see where we'll be. We will be back here in Burton on that day. So we'll be here in Burton. For probable cause conference. Any motions that anyone wants to file, try to get filed by that time, though I'm not doing motion cutoff or anything of that nature, but it'd be a good time for us to discuss those things. We're not going to discuss any of this again because I have addressed it and found it to be irrelevant to this criminal case today. And anything else from anybody?
I do.
Yes, Your Honor. Just briefly, as is our typical office policy with pro per defendants, I will, once I have the body cam for Mr. Sigsbee, I'll have it on a flash drive and I'll hand deliver it to him in court at the next court date. That seems to be the best way to give that discovery. Unless it's another idea.
Can he pick it up at like a clerk's office or something like that?
I don't see why not.
The problem is that we're gonna adjourn it out almost a month. And
Yeah, I
then
don't see why
we're gonna
not.
have to adjourn it again for him to review it, so I don't like that idea.
And I guess I just don't know how I would, well, I think Mr. Hilliker gave us his address. I don't know how I would be able to contact.
Mr. Sigbin, what's your opinion on that?
Well, yeah, I don't want no improper service here, you know, Michigan. Michigan,
Let's.
If there's
see
gonna be
what
an
we're
issue
on
with
that. How do you
service.
want it? How do you want it provided to you?
I will meet up with him at a conference. I'd like to have a conference with the prosecutor.
Well, you're
Well,
gonna
it says so. It
schedule
says so in
that.
Michigan State Constitution, and we pull out paperwork.
No.
and just-
No, stop. All we're talking about, I'm not talking about conferences right now. I'm just talking about getting discovery to people. So if the prosecutor's office, you know what? No, we'll do it this way. It's the only other thing we can do is I'm going to move the PCC. We're gonna have a PCC on August 28th, 2025 at 11 o'clock a.m. That will be to exchange discovery. Okay. So that way we can do it here in the courtroom. There won't be any questions about it. I don't want to put any staff member in a precarious position being accused of things that not delivering things or something along those lines. I don't want to put anybody in that position. So we'll just come back here on August 28th, 2025, 11 o'clock a.m. We'll have a very brief probable cause conference, and that will only be to exchange discovery. If there are any other issues in regards to discovery, we can talk about them too. And then we'll also have another PCC on the 11th. That will give you opportunity.
That answered my next question. That did answer my next question.
Okay.
Okay, because I
Okay.
just want opportunity, and I do object to the prosecutor using the pro se. I'm not pro se, I'm sui juris.
Sure.
Thank you.
However you want to say. Representing yourself, sui juris, pro se,
Myself,
On
I'm not
myself.
Civil War II, so I'm not a civil dead.
presenting
child
myself,
bastards.
all those things. They all mean the same thing. Okay. Thank you, everybody.
Okay, thanks.
Well, guys, we've come to the end of the proceeding of Mr. Robert Sigsbee. definitely had a whole lot to say, definitely had his sovereign citizen head on. I don't know if I heard anything that I haven't heard before. Maybe a couple things he mentioned sounded a little new to me, but for the most part, some of the same arguments that you hear from sovereign citizens. The judge, she definitely wasn't trying to allow the courtroom to get out of control. And as you remember, or maybe you don't remember, we was in her courtroom, I should say, about a week or two ago for the first time, and I saw then that she definitely is not trying to hear any type of nonsense or play any type of games or allow people to take over a courtroom. That is just not happening, and she didn't allow that to happen today. But I do agree that if the prosecutor's office, or I should say the police department, has more body cam footage that they can provide for Mr. Sigsbee, it definitely should be provided, just to give him a fair defense and possibly exonerate him from the way he's talking. So, we'll see what happens with this case. We see there is a continuance. There will be another probable cause hearing. We will try to follow up on that the best we can. And as always, I thank you guys for joining me here. Don't forget to like, comment, share, subscribe, all of the things that has made this channel great so far. With that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, Sovereign Citizens Court is adjourned. Thank you guys. See you guys soon, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.